Hello everyone, welcome back to Legal English through Case Law series. Case Law No. 55/2022/L regarding the recognition of the validity of the contract that violates the conditions on format. This case law was approved by the Supreme People's Court Council of Judges on September 7, 2022, and announced in Decision Number 323/QDCA dated October 14, 2022, of the Chief Justice of the Supreme People's Court. The First Instance Civil Judgment Number 16/2019/DSPT dated March 19, 2019, of the People's Court of Quang Ngai Province on the case, dispute over the land use rights transferring contract, between the plaintiff, Mr. Vo CM, with the defendant, Mr. Don C. Persons with related interests and obligations include 05 people. Case law situation: the land use right transferring contract made before January 1, 2017 has yet to be notarized/certified, but the transferee has fulfilled 2/3 of its obligations. Legal solution: in this case, the court recognizes the validity of the contract. Regulations related to case law: Article 129, Clause 1 of Article 502, and Point B of Clause 1 of Article 688 of the Civil Code 2015, Point A of Clause 3 of Article 167 and Clause 1 of Article 188 of the Land Law 2013. Keywords of case law: land use right transferring, not yet notarized/authenticated, perform 2/3 of the obligations, acknowledge the validity of the contract. 3. Content of the case law: according to the lawsuit petition dated April 18, 2017, amended and supplemented on June 6, 2017, the self-declaration and at the first instance trial, the plaintiffs, Mr. Vo CM, Ms. Feng Tn, presented. Between plaintiffs and defendants have a kinship relationship. In 2009, the defendants needed money to build a house for their son, so they agreed and made a contract to transfer the land use rights to the plaintiffs. The assigned land was Lot B in the defendant's land allocated to them for resettlement by the state. The state has recovered the defendant's land and has announced that the state will provide the resettlement land at Village H, with the price of VND 90 million. The plaintiffs fully paid VND 90 million to the defendants. In 2011, the state indicated the boundary the land position granted to the defendants as 03 adjacent land lots in the front. The defendants and Mr. Don 10 L1 requested the plaintiffs to give an additional VND 30 million because that adjustment made the price higher. The plaintiffs agree to pay VND 20 million, and when the transfer procedures are completed, the plaintiffs will pay the remaining VND 10 million. At this time, the defendants indicated the location and boundary of the transferred land lot to the plaintiffs. While waiting for the procedures to transfer the land use right to be completed, on June 5, 2014, the plaintiffs leased the land area to Ms. M1, address, V Village, P Commune, D District, Quang Ngai Province. Ms. M1 contracted this land area to do business, and no one has any comments. In October 2016, the state issued a land use right certificate to the defendants, but the defendants and Mr. Don 10 L1 only gave the land use right certificate of land lot number 877, map sheet No, hereinafter abbreviated as lot 877, to the plaintiffs but did not carry out the transfer procedures for the plaintiffs. Currently, the plaintiffs have built a split stone foundation on lot 877. Now, the plaintiffs ask the defendants to carry out procedures to transfer lot 877, map sheet number 24, P Commune, D District, Quang Ngai Province, to the plaintiffs. During the settlement of the case, the defendants and the defendants' authorized representative, Mr. T, presented. The defendants admitted that there was an agreement and a contract for the transferring of land use rights as stated by the plaintiffs. When entering into the contract, the defendants were not granted the land by the state. The defendants received the full VND 90 million and then received an additional amount of VND 20 million. This is the money that the plaintiff pay to carry out the procedures for transferring land use rights. After the state recovered the land of the defendant's household, it heard that the state would grant the defendant's family 03 land lots, including 02 lots B and 01 lot A. In the land use right transfer contract clearly specified the self-selected lot B. When making the contract, the state had not yet allocated land to the defendants, so there was no land to assign to plaintiffs. On the other hand, the land use right transferring contract must be written, notarized, or authenticated. The land belongs to the defendant's household with many members, but only the defendant's agreement to transfer is illegal. Therefore, the defendants requested to declare the land use right transferring contract invalid and settle the consequences of the contract as the parties return to each other what they have received. The person with related rights and obligations, Mr. Don Tan L1, presented, I am the defendant's child, and I agree with the defendant's authorized representative's statement. He added that he and his parents sold the land because they were in a difficult situation at that time, and the land use right certificate was handed over to plaintiffs because of threats. He admitted to pouring split stone on the disputed land to make a store for his parents, but because he had not used it, he sold it to the plaintiff for an amount of VND 6,450,000. That the plaintiffs voluntarily built the split stone foundation, Mr. M told him that the plaintiffs arbitrarily made a split stone foundation, but he disagreed and prevented the construction. Persons with related rights and obligations presented, they had the same household registration as their parents when the state recovered the land until now, and they have the right over the family's common property. The fact that the parent and Mr. L1 voluntarily transferred the land use right, which is the family's common property, without their opinion infringes on their rights, so they disagree. They requested that the court rules that the residential land transfer paper dated August 10, 2009 is invalid. The person with related rights and obligations, Ms. LUient T M1, presented, in 2014, she went to the defendant's house to ask to rent lot 877 to open a restaurant, but the defendants said they had sold the land to the plaintiffs, so she went to the plaintiffs to ask for rent. She agreed with the plaintiffs to rent the land to open the restaurant and pay annually. She hired the defendant, Mr. C, to set up a restaurant for her. After conciliation in the commune, she saw Mr. L1 pouring split stones on the land lot. When the plaintiff built the foundation of the house for 2 days, Mr. L1 came and did not allow it to be built. She has no opinion on the plaintiff's claim, but when allocating land to someone, she will dismantle the restaurant herself and not ask for anything. In the first instance civil judgment number 22/2017/DSST dated September 21, 2017, of the People's Court of Duc Pho District, the court decided to accept the plaintiff's claim. Recognition of land use right transferring contract dated October 8, 2009 and forced the defendants to carry out procedures to transfer lot 877 to the plaintiffs. The defendant's counterclaim for the cancellation of the land use right transferring contract dated August 10, 2009, was not accepted. In addition, the first instance judgment also rules on procedural costs, court costs, and the party's right to appeal. On October 2, 2017, the defendant and those with related interests and obligations filed an appeal, requesting the Court of Appeal to cancel the first instance judgment for resettlement. At the appellate court hearing, the appellants changed the contents of their appeal, requested the trial panel, Hoi Dong Zet Su, to amend the first instance judgment, declared the land use right transferring contract dated August 10, 2009, invalid, and resolved the consequences of a void contract. On October 5, 2017, the head of the People's Procuracy of Duc Pho District issued decision number 1317/QDKNPTVKSDS, requesting the appellate court to amend the first instance judgment and not accepting the petition of the plaintiffs, accept the counterclaim of the defendants, declare the land use right transferring contract between the plaintiffs and the defendants invalid, and the parties must return to each other what they have received. At the appellate court hearing, the representative of the Procuracy withdrew all appeals. The appellate civil judgment number 24/2018/DSPT dated February 1, 2018, of the People's Court of Quang Ngai Province, ruled, amending the first instance civil judgment number 22/2017/DSST dated September 21, 2017, of the People's Court of Duc Pho District, not accept the plaintiff's petition, accept the defendant's counterclaim. On September 19, 2018, the Chief Justice of the High People's Court in Da Nang issued a cassation decision number 68/2018/KNDS dated September 19, 2018, requesting to cancel the appellate civil judgment number 24/2018/DSPT dated February 1, 2018, of the People's Court of Quang Ngai Province, handing over the case to the People's Court of Quang Ngai Province for retrial. The cassation decision number 93/2018/DSGDT dated November 29, 2018, of the Judges Committee of the High People's Court in Da Nang, declared, accepting the cassation decision number 68/2018/KNDS dated September 19, 2018, of the Chief Justice of the High People's Court in Da Nang, cancel the entire appellate civil judgment number 24/2018/DSPT dated February 1, 2018, of the People's Court of Quang Ngai Province, and handed over the case to the People's Court of Quang Ngai Province for retrial. According to appellate procedures. Opinion of the representative of the People's Procuracy of Quang Ngai Province at the appellate court hearing. The judge, the trial panel, the clerk, and the involved parties have strictly complied with the provisions of the Civil Procedure Code. The appeal made by the defendants and those with related interests and obligations within the statutory time limit is valid. Regarding the content of the land transferring contract is the residential land transferring paper dated October 8, 2009, which was made by the plaintiffs handing over 90 million VND to the defendants. After that, because the defendants were not granted resettlement land, which is Lot B, the parties changed the agreement to transfer Lot A for VND 120 million, the plaintiffs continued to pay another VND 20 million, the remaining VND 10 million would be paid by the plaintiffs upon completion of the transferring procedure. Based on the presentation of Mr. Pham Van H., record number 190, and the presentation of Ms. Nguyen T. M1, record number 118, there is a basis to determine that the defendants have assigned land and the land use right certificate to the plaintiffs. The plaintiffs built the foundation of the house and leased it to Mrs. M1 as a restaurant. The land use right certificate has the defendant's name on it, so the defendants have the right to transfer it without consulting other household members. The contract that violates form but is being performed should be applied to the Civil Code 2015 to settle. According to the provisions of Clause 2, Article 129 of the Civil Code 2015, this contract will be recognized as valid. However, the first instance level did not force the plaintiffs to pay another VND 10 million to the defendants, which was a mistake. Proposing the trial panel based on Article 289, Clause 2, Article 308, Article 309 of the Civil Procedure Code, suspending the appellate trial on the part of the People's Procuracy of Quang Ngai Province withdraws the appeal of the Director of the People's Procuracy of Duc Pho District, not accept the cassation of the defendant and those with related interests and obligations. Amending the first instance judgment, recognizing the validity of the transferring contract of Lot 877, the plaintiffs are obliged to pay the defendants 10 million dong. The plaintiffs are entitled to contact a competent state agency to obtain a land use right certificate for Lot 877. 4. Court's findings. At the appellate court hearing, the representative of the People's Procuracy of Quang Ngai Province withdrew the entire appeal decision number 1317/QDKNPTVKSDS dated October 5, 2017 of the Director of People's Procuracy of Duc Pho District. Therefore, suspending the appellate trial of a part of the case that the Procuracy has withdrawn its appeal is consistent with the provisions of Article 284 of the Civil Procedure Code. Before the first instance court issued the judgment, the involved parties in the case did not request the application of the statute of limitations, so they did not consider applying the statute of limitations for initiating lawsuits as prescribed in Clause 2, Article 184 of the Civil Procedure Code. The defendants, Mr. C and Mrs. L, and persons with related interests and obligations, Mr. L1, admitted, due to knowing that the defendant's family has had their land recovered, they will be granted 3 resettlement land lots, including 1 Lot A and 2 Lots B. So on August 10, 2009, the plaintiffs, Mr. M, Ms. N, and the defendants, Mr. C, Ms. L, and Mr. Don Tan L1, agreed and made a residential land transferring paper, record number 27. The content of the agreement is that the defendant and Mr. L1 transfer to the plaintiff a lot of land in Lot B, an area of 5m x 20m, optional when the state allocates land, in the part of the defendant's family's land which will be granted for resettlement with the price of VND 90 million. Mr. L1 is responsible for applying for the certificate of land use right and allocating land to the plaintiffs. All parties involved in the transaction agree to sign. The defendant has fully handed over VND 90 million to the plaintiffs. These details do not have to be proved according to Clause 2. Article 92 of the Civil Procedure Code. The defendants did not admit that there was a change in the transferring agreement from Lot B to Lot A for VND 120 million as stated by the plaintiffs because the defendants were not granted a land use right certificate until 2016. The amount of VND 20 million was received by the defendants just to make a certificate of land use rights, but at the appellate court, Mr. L1 admitted in 2011 that the defendants knew the location of the 3 land lots that the defendant's family was granted for resettlement on the map. There was no Lot B as agreed with the plaintiffs. 03 land lots includes Lot 877. Besides, in the minutes of taking statements of the litigants, record number 192, Mr. C stated that he had built a house on 01 lot of land for resettlement since 2013. Thus, although the certificate of use right has not been issued yet, the defendants knew the location of the resettlement land lots that would be granted by the state. Based on the actual use of Plot 877, the land tenant's testimony, Ms. Nguyen TM1, land lease agreement, record number 27, Don C's statement on July 25, 2017, record number 192, proves that the defendants have handed over Lot 877 and the land use right certificate to the plaintiffs. The plaintiffs have leased the land to Mrs. M1 to build the restaurant. Mr. C also came to build the shop for Mrs. M1, and there was no dispute. Mr. L1 himself poured split stone on Lot 877 and sold it to the plaintiffs so that the plaintiffs could build the foundation of the house. Regarding the time limit for performing the transaction, it is determined by the 2 parties to be from the time the transaction is established until the defendant fulfills the obligation to transfer land use rights to the plaintiffs, so this is a transaction being performed. Regarding content and form, it is consistent with the provisions of the Civil Code 2015. So the application of the Civil Code 2015 is following the provisions of Point B, Clause 1, Article 688 of Civil Law 2015. Thus, although at the time when the parties agreed on the transfer of land use rights, the defendant had not been granted land, so they only made a handwritten paper showing the content of the agreement when the land was given, the parties changed the agreement verbally to transferring the Lot 877 and continued to perform the contract by paying more money, allocating land, handing over the land use right certificate. The time of handing over the land use right certificate in the defendant's name was already eligible for transfer. According to the provisions of Article 116, Clause 2, Article 129 of the Civil Code 2015, the transaction of transferring land use rights of the parties does not comply with the form specified in Clause 1, Article 502 of the Civil Code 2015. But the plaintiff has delivered to the defendant 110 million dong, the defendant has assigned the land use right to the plaintiff, and has performed more than 2/3 of the obligations in the transaction, so the transaction is recognized as valid. The first instance court recognized the transaction's validity as legal, but forcing the defendant to carry out procedures to transfer Lot 877 to the plaintiff was unnecessary. When the court recognized the transaction's validity, the plaintiff contacted the competent state agency to have the land use right recognized according to the legally effective judgment. Persons with related rights and obligations, Don Tan L1, Don Tan N1, Don T Thursday V, Don T My N2, who are members of the defendant's family, claiming that their parents transfer the land use right without their consent, affecting their legitimate rights and interests, find that, according to the land use right certificate, Lot 877 is land for resettlement granted to the defendant, not to the household, so the defendant has the right to transfer. The defendant's transfer Lot 877 of the defendant does not violate the prohibition of law such as the defendant and those with related interests. Obligations. In case Lot 877 is the common property of the household, the defendant only transfers one of the 3 resettlement land lots, so it is still within the scope of the defendant's property rights in the common property of the household. From the above finding, we do not accept the appeal of defendants Mr. C, Mrs. L and those with related rights and obligations. However, according to the transfer agreement, the plaintiff still has to pay the defendant 10 million VND. The first instance court recognized the contract but did not force the plaintiff to continue to pay the remaining amount. That is a mistake. It is necessary to amend the first instance judgment on this content. At the appellate court, the plaintiff voluntarily let the temporary restaurant with an area of 25 square meters built with eucalyptus trees, iron corrugated iron roof, and cement floor of Mrs. Nguyen TM1 continue to exist on the land, in case the court accepts the plaintiff's petition. As the finding above, the plaintiff is a legal land user, so the plaintiff's voluntary consent should be acknowledged, for the stone foundation that the plaintiff built on land lot 877. Map sheet number 24 of Commune P is valued at VND 9,400,000 because the plaintiff purchased materials and built it himself, so it belongs to the plaintiff. Other parts of the first instance judgment of the trial court following the law shall be upheld. The opinion of the representative of the People's Procuracy of Quang Ngai Province is grounded and follows the law, so that opinion should be accepted. The defendant is an elderly person and has an application for exemption from court fees, so the exemption of appellate civil court fees for the defendant is consistent with the provisions of Point DD, Clause 1, Article 12 of Resolution Number 326/2016/UBTVQH 14 December 30, 2016, of the National Assembly Standing Committee, the persons with related interests and obligations, L1, N1, V, and N2, who are not subject to appellate civil court costs, which is consistent with the provisions of Clause 2, Article 148 of the Civil Procedure Code. For the above reasons, decide. Applying Clause 1, Article 147, Clause 2, Article 148, Article 289, Clause 2, Article 308, Article 309 of the Civil Procedure Code, Article 116, Clause 2, Article 129 of the 2015 Civil Code, Article 106 of the 2003 Land Law, Point DD, Clause 1, Article 12 of Resolution Number 326/2016/UBTVQH 14 dated December 30, 2016, of the National Assembly Standing Committee, suspension of the appellate trial in part of the case against the appealing decision number 1317/QDKNPTVKSDS dated October 5, 2017, of the Procurator General of the People's Procuracy of Duc Pho District, do not accept the appeal of the defendants and those with related rights and obligations. V. Rules, partial correction of the first instance civil judgment number 22/2017/DSST dated September 21, 2017 of the People's Court of Duc Pho District. 1. Accepting the petition of plaintiffs, Mr. Vo C.M. and Ms. Feng T.N., recognizing the validity of the contract of transferring the right to use land lot number 877, map sheet number 24, Commune P between Mr. Vo C.M., Ms. Feng T.N. and Mr. Don C., Ms. Tran T.L., Mr. M. and Ms. N. have the right to use land plot number 877, map sheet number 24. Commune P. Mr. M. and Mrs. N. are obliged to contact the competent state agency to obtain a certificate of land use right for land lot number 877, map sheet no. 24, Commune P, District D, Quang Ngai Province. Mr. Vo C.M. and Ms. Feng T.N. are obliged to pay Mr. Don C. and Ms. Tran T.L. 10 million VND, 10 million VND. 2. Do not accept all counterclaims of Mr. Don C., Ms. Tran T.L., and those with related rights and obligations, Mr. Don Tan L1, Mr. Don Tan N1, Ms. Don T Thursday V, Ms. Don T My N2 on declaring the land use right transfer contract on August 10, 2009, invalid and dealing with the consequences of the invalid contract. 3. Noting the willingness of Mr. Vo C.M. and Ms. Feng T.N. to let the temporary restaurant with an area of 25 square meters built with eucalyptus trees, iron roof, and cement floor continue to exist on land plot number 877, map sheet number 24, Commune P. 4. Noting the willingness of Mr. Vo C.M. and Ms. Feng T.N. to bear the costs of the on-site appraisal. 5. Regarding court fees, 5.1. Mr. Vo C.M. and Ms. Feng T.N. were not required to bear the first instance civil court costs, refunded 300,000 VND, 300,000 VND, in advance of the court fees paid by Mr. M. and Ms. N. according to Receipt No. AA/2014/003747 dated June 7, 2017, of the Civil Judgment Execution Subdepartment of Duc Pho District, Quang Ngai Province, 5.2. Mr. Don C. and Ms. Tran T.L. were exempted from first instance and appellate civil court fees, 5.3. Mr. Don Tan L1, Mr. Don Tan N1, Mrs. Don T Thursday V, and Mrs. Don T My N2 are not subject to appellate civil court costs. Refund to each person 300,000 VND, 300,000 VND, in advance of appellate court fees paid according to the Money Collection Receipts No. AA AA/2014/0003856, AA/2014/0003859, AA/2014/0003857, AA/2014/0003858 on October 19, 2017, of the Civil Judgment Execution Subdepartment of Duc Pho District, Quang Ngai Province. 6. From the date the judgment creditor files a written request for judgment enforcement, the judgment debtor who is late for judgment has to pay interest on the amount of late judgment enforcement corresponding to the delayed judgment execution time at the rate of interest agreed upon by the judgment creditor and the judgment debtor. If no agreement is reached, the provisions of Clause 2, Article 357 of the Civil Code 2015, 7. In case a judgment is executed according to the provisions of Article 2 of the Law on Civil Judgment Execution, the judgment creditor and the civil judgment debtor have the right to agree on judgment enforcement and the right to request judgment enforcement, voluntarily execute judgments or are forced to execute judgments under Articles 6, 7, 7a, 7b and 9 of the Law on Civil Judgment Execution. The statute of limitations for judgment enforcement shall comply with the provisions of Article 30 of the Law on Civil Judgment Execution. 8. The appellate judgment takes legal effect from the date of its pronouncement. Case law contents. 6. Regarding the time limit for performing the transaction, it is determined by the two parties to be from the time the transaction is established until the defendant fulfills the obligation to transfer land use rights to the plaintiffs, so this is a transaction being performed. Regarding content and form, it is consistent with the provisions of the Civil Code 2015, so the application of the Civil Code 2015 is following the provisions of Point B, Clause 1, Article 688 of Civil Law 2015. Thus, although at the time when the parties agreed on the transfer of land use rights, the defendant had not been granted land, so they only made a handwritten paper showing the content of the agreement when the land was given, the parties changed the agreement verbally to transferring the lot 877 and continued to perform the contract by paying more money, allocating land, handing over the land use right certificate. The time of handing over the land use right certificate in the defendant's name was already eligible for transfer. According to the provisions of Article 116, Clause 2, Article 129 of the Civil Code 2015, the transaction of transferring land use rights of the parties does not comply with the form specified in Clause 1, Article 502 of the Civil Code 2015. But the plaintiff has delivered to the defendant 110 million dong, the defendant has assigned the land use right to the plaintiff, and has performed more than 2/3 of the obligations in the transaction, so the transaction is recognized as valid.